Okay, I'm going to go ahead and get started. I apologize, I'm running a few minutes late, but I think I've only got one student waiting on me, and we now have everything in order. I'm going to pull up a couple things, and then I'm going to share my screen with you here in just a second. First bit of housekeeping is please, I have about 25% of the class that has not yet taken the mandatory attendance verification quiz. I cannot help you if you do not take that attendance verification quiz. You will be dropped from the class. It may mess up if you have any financial aid. It may mess that up. There's all kind of problems that it can occur. We have an exam Wednesday, which means that in the event you seek to be reinstated in the class, you will likely miss the first exam, and that's a zero. Yes, it can be made up with uh, the final exam, whatever percentage grade you get there, or you can drop it as one of your two lowest grades or both. But the fact is, you've blown some opportunity to take the exam. So, having said that, for the 75% of you or so that have taken the attendance verification quiz, thank you. And I'm going to go ahead and get started. Today, what we're going to do is I'm dividing this into two parts. The first part is going to be focused solely on the exam that we have coming up, which is courts and alternative dispute resolution. And then after I've concluded that and checked to see if there are any questions, I'm going to switch to the Liebeck versus McDonald's case, which is the exam the week after that. As you recall, we have an exam beginning Wednesday, September 3rd, and then we will have an exam every Wednesday for 10 consecutive Wednesdays. So it will come hard and heavy, fast and furious. And so you're going to need to be ready for that. I will likely change the Zoom schedule that is on your class syllabus. I will likely change that and consolidate and do a little bit more of this two at a time because I think that you guys get sick of seeing me and clicking on these things anyway. But as always, if you have any questions about anything, feel free to reach out to me to see if I can help you. I also have a video that I am preparing on how to study for law. I'm doing it on my law practice channel. I'll send you that if you're interested later, but it has nothing to do with the class per se. Okay, I'm going to go ahead and pull up some chicken scratching notes. I don't know why I'm going to share it with you because I'm not sure that you could even read it, but I'm going to share the screen with you anyway so that you can look at those notes and have something to see other than just me, which I'm sure is an improvement. Make it a little bit bigger. What did I just do? Oh no, I went to another page. Okay. That didn't do it either. Okay, I'm just going to leave it there. It's maybe that does it. No, that's text. I'm not going to worry about it at this point. Um, Courts and alternative dispute resolution. Let me check the chat real quick to see if there's a question. No, there's not. Okay. There's a lot of material here for courts and alternative dispute resolution. And a lot of times students don't think that there's a lot of material because it doesn't appear to be a lot of pages. But if you look at, for example, the one page that I have on Alabama trial courts, the Alabama court system, you'll see different things on that one page, and I probably could ask 100 questions at least related to those issues. For example, It deals with state trial courts being district court and circuit court. And it talks in terms of, well, district court has a jurisdictional limit of $20,000 and circuit court has a unlimited jurisdiction, and there's concurrent jurisdiction between state court, state circuit court, and state district court. Uh, but only when it is above $6,000, because from 0 to $6,000, district court has exclusive jurisdiction. And district court only has trials in front of a judge, and a jury is available only for state circuit courts. So and then there are other questions like you've got 14 days to respond to a complaint filed against a defendant in district court, which includes small claims division, and you have 30 days to respond to a complaint filed in circuit court. Um, so you have all those kind of things, and it sounds pretty simple at first. And then you start to have questions. Well, let's see. Fred wants to sue Mary in state court, and he wants a jury to hear the case, and he wants to sue for $5,500. Well, unfortunately, he can't do what he wants to do because he can file suit in state court, more than likely, but he cannot file and get a jury. Why not? Because he's only asking for $5,500. And from 0 to $6,000, state district court has exclusive jurisdiction, meaning they're the only ones that can hear the case. And state district court, unfortunately, does not have a jury available. Only circuit court does. Well, why can't he file it in circuit court? Well, because circuit court only has jurisdiction beginning above $6,000, and that's the reason why you can't get a jury in that case. I might ask a question related to a lawsuit that's been filed and a default judgment has been entered. Default judgment is a judgment that's entered by the judge when the defendant has failed to respond within the appropriate time limit. And I may say something like, after X number of days, uh, a default judgment has been entered. You know that the case was filed in blank court. And that might be a true or false question, or it might be a fill in the blank question, or it might be a short answer or something like that. But what will be important is that you'll have to know what all the different courts are and what all the different limitations are. Uh, we're going to have at least 4 different numbers that you're going to have to keep up with. A state circuit court, which is 30 days to respond. State district court, which includes small claims division. And if I say small claims court, it's the same thing as district court. It's the small claims division of district court, but I might say small claims court and district court, and that's 14 days. And then you have federal court, and federal court has at least 2 different scenarios where you have a 21-day response period necessary for most defendants, and then a 60-day response period for the federal court. I'm sorry, for federal government, if the U.S. government is a defendant. So there may be all kind of different things that are available for that. And you'll have to pay close attention in order to make sure that you are going to get that question right. It's very easy to get it wrong. Let me say this, and I think this is important. The attendance verification quiz that I gave, most students there's about 60% that students are getting on average on the exam. Now, some students are getting all 10 points, but the average is about 6 out of 10. And that includes 2 of the points that should be just a gimme, which is basically signing your name to an affirmation that you did not use artificial intelligence to answer the questions, which is something you're going to be required to do on every exam, by the way. Every exam you're going to be required to affirm that. If you do not affirm that, you will get a 0 for the exam. And if you affirm that and you are found to have violated that, you will be asked um, to leave the class and recommended for expulsion from the university. That's just my rule, and that's the way that I believe it is. I think that's the right thing to do. You need to learn the things first and then use artificial intelligence. I use AI every day, but by golly, I know what the law is because I've studied it and I can use it and I can use AI to assist me with it, not to answer for me. And that's where I'm going to go with you guys. But the point I was making um, on the attendance verification quiz, you're not paying attention to detail. It's really critically important that you do so in a law class. For example, some of you are guessing. There's a question related to something about getting a makeup exam, and so many of you talked about a doctor's note or an excused absence or whatever. No. Yeah, that's what normally happens in most classes, so that's a good guess. It just happens to be wrong in this class. You're not paying attention to detail. Law is about critical analysis of detail. We have no homework assignments in this class, which means you have extra time to do this. And one of the things I'm going to talk about in my how to study for law is sort of the old adage about advertising. In advertising, you tell them what you're going to tell them, then you tell them, and then you tell them that you told them. And it's kind of the same way for active studying for law. You read the material, you then listen to audio lectures, watch video lectures while taking notes, and then you go back and review those notes and that material in an active kind of way in order to start to learn it. I'll talk more about that later on that separate video, but I do want to mention it for this purpose as well. Um, you'll need to know things like on the exam, the difference between a general jurisdiction court and a limited jurisdiction court. And I may just throw some court out there and say this court is a court of general jurisdiction, or this court's a limited jurisdiction court. Or I may ask you to give me an example of one. Um, you only need to know the difference between exclusive jurisdiction and concurrent jurisdiction. I've talked about that already today, where a state district court has exclusive jurisdiction from $0 to $6,000 for state law cases, and they have concurrent jurisdiction with circuit court for matters in excess of $6,000, and circuit court has concurrent jurisdiction with them for the same things. You'll need to know the difference between trial courts and appellate courts, how to apply precedent. And we happen to have a weird situation. We are part of the 11th Circuit Court of Appeals, which is relatively new. It's only 44 years old. That's relatively new. We were part of the Fifth Circuit Court of Appeals at one time, part of New Orleans, part of Louisiana, Mississippi, and Texas. No longer. We are now part of Alabama, Florida, and Georgia Circuit Court of Appeals. What does that mean? Well, it means that 11th Circuit Court of Appeals is our binding precedent today, but it can't be binding precedent in 1977, say, because that was before 1981 and before it was created. So what happens then? Well, in that case, we are the Fifth Circuit has binding precedent over us. But what if the 11th Circuit now rules on the issue and it's different than the Fifth Circuit? Well, the 11th Circuit always takes precedent over the Fifth Circuit. So some questions like that, and I may give you some fact scenarios that complicate matters where you really have to know the stuff. This is not like memorizing history dates. You have to know it to the point where you can really critically think about this thing and say, oh, well, gee, I know this because of this. And the only way you do that is by going over and over and over this kind of stuff. Okay, that's really all that I have for the courts and alternative dispute resolution. At this point, I'm going to see if there are any questions from the audience, people who are in the audience. Uh, if so, speak now or forever hold your peace. And as a reminder, uh, this is being live streamed on the class YouTube channel and recorded. So do not reveal, discuss any private information. This is public. So please limit questions to that of a public nature, if you have any. Okay, great. I appreciate that. And at this point, I'm going to switch and I'm going to discuss the Liebeck versus McDonald's case. So everything from this point forward will be just related to Liebeck versus McDonald's. So you can kind of tune out if you want to wait and study for that later. But I'm going to go ahead and pull up now my little cheat sheet notes on Liebeck versus McDonald's. Don't really have that much on this one, and that's kind of part of the reason why that I wanted to combine these two, because there's not a whole lot with Liebeck. Liebeck case is going to be important because it's going to show a couple things. One, I always enjoy this case, and again, this is not in the textbook. This is just my material only. Um, it involves a case that was widely reported on, and this is many years ago. A lot of you may not even have been aware of this case, but it was the hot cup coffee cup case where the dumb lady spilled coffee and got $1 million, and everybody made fun of her. Um, Hopefully, when you review the material that I have provided, it may open your eyes on some of the things to show that really the case wasn't quite what you may have heard that it was. And what is going to be really important for purposes of this exam, again, focusing critical detail, is paying attention to detail. What's going to be very important is not necessarily what happened, but why it happened. In other words, in the case, just to give you a little preview, the court awarded $2.7 million in punitive damages, and they also awarded uh, uh, money for compensatory damages as well. Well, there's a difference between compensatory damages and punitive damages, as you'll learn next week. And then again, when we discuss torts as well. And so I may say something like, well, the court awarded this amount of money to punish this company for doing this or whatever. Well, that may or may not be accurate, because you'll have to know, well, wait a minute, was that compensatory damages? Was that a part of compensatory damages? Was it a part of punitive damages? Which one was it? Critical attention to detail is going to be a prime element for the questions on that section, that area of law. And I think it's a good training session for the remaining portion of the semester. I'll ask you why things happen. You know, this case was a bad case for McDonald's. It didn't have to be a bad case for McDonald's. It tried very, very poorly for them as a result of some very critical things that came out in evidence, and some very critical things that came out during testimony, both in depositions and live testimony, not just from Ms. Liebeck and her team, but from McDonald's standpoint. And so I think a lot of it's important for you to understand that as well. A lot of you will go into business later on, and you'll either own a business, or you'll manage a business, or you'll be in management somehow, and it'll be important for you to understand what your exposure might be in certain circumstances. And it's also going to be important for you to understand how things can turn on their side in a hurry, or turn upside down in a hurry. And I think the Liebeck versus McDonald's case is a great example of that. The case tried very poorly for a lot of different reasons, and I'll hit on some of those reasons on the exam. Um, and that exam may be one where you first start to say, gee, Mr. Cartwright has tricky exams. No, I don't have tricky exams, not in my opinion. What I do have are exams that require strict attention to detail. Law is about detail. Law is, it's funny. I was thinking about it. My kids are all older now. I've got 3-year-old grandchildren. They're not quite at this point, but when they get a little older, assuming I'm still teaching this class, and I hope that I still am. I've taught it for 15 years, and I hope to teach it for 15 more. But when they get a little bit older, I'm going to use them as an example, and I'll say, well, my grandchildren, they're in the third grade now. They can read law, but their critical analysis and their attention to detail on that law, their ability to recall that law and to recall the details of that as it applies to certain fact patterns, not just ones they've heard about or read about, but future ones, is non existent. They don't have that. Well, you have to have that for this class. You have to have that in order to apply law, period. So I'm going to do my very best to help you learn how to learn with these kind of questions, with this kind of attention to detail. It's a hard class. You'll see. It's a hard class. You will do well if you follow my recommendations and advice. Work hard in the class and do little things like the Cornell method of note taking and again, reviewing the material before you watch the lectures, and then watch the lectures and listen to the lectures and take good notes during the lectures with the Cornell method of note taking, or whatever works for you, and then going back and reviewing them. And I know this is an online class, and it's very hard to formulate groups, but group study is a great way to learn law. A lot of times that you can learn from other students and their perspective. But back to Liebeck versus McDonald's, compensatory damages, punitive damages. You'll need to know the difference between those, how that applies differently, what was awarded in the Liebeck case, for what reasons something was awarded. I won't necessarily say, well, they awarded X dollars for compensatory damages. I may say they awarded so much to punish this company, or they awarded so much because of the injuries that this lady suffered, or whatever. And we'll see this again when we go to the torts section of the class, and you have the an additional test on this as well. The difference between comparative negligence and contributory negligence. We happen to be in an unusual state. We are in Alabama, and Alabama uses the contributory negligence doctrine. We are the only state that uses contributory negligence doctrine, and it may have had a different the McDonald's case may have had a different result in Alabama because of that. And you'll have to know why that is and how that is. And I may give examples for different fact patterns in different jurisdictions, including Alabama, but not necessarily just limited to Alabama. And you'll have to figure out which one applies and what the result may have been. And the same thing for comparative negligence. Comparative negligence has certain elements to it that you have to know and be able to apply. And you'll have to look at the negligence of the plaintiff and the negligence of the defendant, if each of them have some portion of that. Like this in the Liebeck case. In the Liebeck case, you'll learn factually. The jury said, yeah, Miss Liebeck, you were partially at fault for your own injury. Yeah, McDonald's, you were partially at fault for her injuries as well. We're allocating more of it to McDonald's because it was unreasonably hot, and because you had injured 700 people before and you just weren't going to fix it. And your own people said, gee, it's too hot for humans to drink at the temperature we serve it, and a lot of other things. But in any event, the jury said, gee, we've got different amounts of negligence or responsibility for the injury, and this is how we're going to allocate it. And you're going to need to know how comparative negligence works in that situation. I may give you different numbers for different fact patterns and ask you, and if there's this much damage and there's this much percentage responsibility on the plaintiff and this much percentage responsibility on the defendant, what is the result? And you'll have to figure that out and analyze it and correctly get the answer. Okay, that was pretty much a rush through. I'd recommend uh, if you've watched it to this point, watch it again. Slow it down, maybe. Sometimes I get talking kind of fast, and I'm doing my best to not waste your time with things and keep on topic. I'm assuming there are no questions on the McDonald's case because you probably haven't heard of anything yet, or haven't started reading it yet. If you do, let me know while I'm continuing to kind of wrap up here. Um, but otherwise, the one thing I'm going to say here at the end again is if there's something I can do to help you, let me know. There are no tricks. There are no tricks that can be done. There is no extra work that any individual student can do. If your exam grades aren't what they should be, look for possible bonus opportunities when I present them during the semester. I usually do a few times. And then keep in mind, you've got basically 10 weekly exams. Two of them get dropped as low as of their your lowest two grades. If you miss an exam, it doesn't count as a zero. I said a zero earlier. It's not really a zero. It's going to be whatever your final exam percentage grade is. You make an 80% on your final exam. That missed exam is an 80%. You don't get to take a makeup. It's 80%. But then you drop the two lowest grades. So keep that in mind. If you do poorly on these first couple of tests, hopefully you'll pick it up after that. The more of these you take, the better you'll get at them. Okay, having said that, thank you for my student that attended today, and good luck with the exam. Wednesday, it should open around 6 o'clock in the morning. Sometimes there's some glitch. The glitch is usually me. And somebody says, "Hey, professor, it hasn't posted for me yet." And I'll get that message at 9 or 10 or 11 o'clock in the morning and I'll fix it. And so it may be that, but once it's open, it'll be open until 11:59 p.m. So all day, all night until midnight. Good luck with the test. Let me know if there's anything I can do to help you, and I'll see you next time.